Have you ever wondered what happens to someone's belongings and property after they pass away if they did not leave clear instructions? It is a question many of us ponder, perhaps hoping it never applies to us. When a person dies without a valid will or trust, their estate is considered intestate. This means state law, rather than their personal wishes, dictates how their assets are distributed. It is a common situation with specific legal procedures. The core mechanism is known as intestate succession laws. Each state has its own unique set of rules that determine which relatives inherit the deceased person's property. These laws typically prioritize close family members. For example, a spouse and children are usually first in line, followed by parents, siblings, and then more distant relatives. The exact order and percentage shares can vary significantly from one state to another. These rules do not consider personal relationships, needs, or what the deceased person might have wanted for specific heirs. To navigate an intestate estate, the first step is typically for a family member to petition the probate court to open an estate and appoint an administrator. This individual, often a surviving spouse or adult child, takes on the responsibility of managing the estate. They gather assets, pay any debts, and then distribute the remaining property according to the state's intestate succession laws. This process is often public and can be time-consuming and expensive. An important insider detail to understand is the concept of probate assets versus non-probate assets. Intestacy laws only apply to probate assets, which are those solely owned by the deceased without a designated beneficiary. Assets like life insurance policies, retirement accounts with named beneficiaries, or jointly owned property with rights of survivorship are considered non-probate and pass directly to the named individual or surviving owner, regardless of whether a will exists or if the estate is intestate. This distinction is crucial for understanding what property is actually affected. Understanding that state law takes over in the absence of a will or trust underscores the immense value of proactive estate planning. By creating a valid will or trust, you ensure your legacy reflects your true intentions, providing clarity and peace of mind for your loved ones, saving them potential legal complexities and emotional distress, and avoiding the default rules that might not align with your wishes at all.